Can't
Yeah,
remember.
we were on the record, and then we had to iron out that issue.
Oh,
Okay.
that's right.
We'll go back on the record on Mr. Walker's case. I gather the parties were able to chat, and it turns out the information does have the correct dates, but a day of the week is incorrect. Is that correct, Mr. Anderson?
I think so, Judge. I went and checked the notes of ADA Dennis Murphy, who covered the preliminary hearing. He made contemporaneous notes that essentially say that count 6, which had been denominated as, I think, October 21st, that the officers testified at the prelim, that it was in fact on the 20th, and that he made note that he in fact changed the information to the correct date, the day of the prelim, and filed it. The only thing that can't be true is it can't be a Wednesday, because in the prior count, I believe it's count 4, it references Tuesday, October 20th, and now it says Wednesday, October 20th. And I think that's just essentially a Scrivener's error on Mr. Murphy's part, where he failed to take out the day of the week.
Day of the week in count 6?
Correct. So the stay would be moved to just to strike the word Wednesday.
That's fine. I'll grant that request. Okay, so Mr. Batt, did you get a copy of the information?
Yeah, I downloaded it and reviewed the information. And I would waive its reading at this point then, and enter pleas of not guilty.
How would you like to schedule this?
There are two things more, Judge. One, if you notice, I think it should be in the complaint or in the docket sheet. I did ask for it to be set over for today also to be heard regarding bail.
Sure. Well, I'm happy to hear bail in just a second. I assume that you're going to need a scheduling date. Did you get discovery on this?
No, but the other thing now, though, too, is that I finally got out and really to talk with him at the House of Corrections over the weekend. And from things that he was telling me and talking with me about, I would be at this time, I feel I need to request a competency evaluation on Mr. Walker.
All right. So competency evaluations are governed by Wisconsin Statute 971-14. Hold on, let me get my notes in front of me. I'll find that there's reason to doubt Mr. Walker's competence. We'll schedule this for I'll appoint a doctor to evaluate him. I'll appoint the forensic unit, and we'll schedule this for a return on doctor's report in about 30 days.
Judge, then we're not doing an arraignment, I take it.
I think that Mr. Batt already entered a plea on behalf of Mr. Walker. We can go ahead and I can accept a plea, I think, even in spite of the challenge to his competence because of the timing on how it was entered. But we can reaffirm that on the next date if we need to.
All right. Yeah, can we still hear bail though? Because he was asking mainly to a lot of times at the House to be heard today on bail.
It's the state's position, everything is suspended at this point. With the exception of the limited things that the statute allows. Bail is not one of them, as I recall.
Let's see what the doctor's report has to say, Mr. Batt. We'll schedule this for a return on doctor's report and a bail hearing, and we'll go from there.
All right.
Council, sometime the week of April 5th.
Earlier in the week would be better. I can do anytime in the morning on the 5th, 6th, or 7th. Maybe the 5th.
How about 10 o'clock on the 6th?
All right.
Okay, April 6th at 10 o'clock for return on doctor's report. That'll be by Zoom. Same Zoom information as today.
Okay, I'll see everybody then on the next court date.
All right, thank you then, Judge.
You're welcome. See you all then. Thank you, Mr. Walker. I'm going to go ahead and disconnect now.
Matt, were you able to find out where Estrada, if he's in or out?
So it looks like he posted the bail. It was a low cash bail
Oh.
for the longest time, and it looks like he's now posted it.
Okay. Well, we haven't heard from him.
Right, and I haven't either, so I'll definitely ask to put it off to the afternoon or something like that, where I can make efforts to reach out and find phone numbers for him.
And you're back this afternoon?
I am on Mitchell.
Okay, well, if the judge okays that, that's fine with our calendar. I'll
Okay,
call Hawkins first.
okay,
I'm gonna let Wallace in because they've been in the waiting room for a while.
okay.
State of Wisconsin versus James Hawkins, 20 CF 03118 appearances.
State by ADA Anderson.
Attorney Matt Lamke appears on behalf of the defense. Mr. Hawkins is in custody at the House of Corrections.
Okay, so we're set for a status conference today. What's the status, Mr. Lamke?
I think I'll go ahead and set it for projected guilty plea. There's a little bit more tweaking that needs to be done, but I think we have enough information where I think it's appropriate to do that. I'd ask for PGP only, though.
You know, I'm willing to do that. Is there a good reason to do that, though? It's much more efficient to do it all at once.
Then I'd ask for a date further out, just to give me a little bit more time to cover the bases.
Okay, well, so I'll give you about 45 days or so for plea and sentencing.
Okay.
Matt, how about, does this need to be in person or can it be by Zoom?
Well, you know, I haven't had that conversation with him yet. For now, I'd be willing to set it by Zoom because I think that would work and make some sense. He is in custody. I know he's going to prison already on a revocation matter.
So he's not going anywhere for a while.
Correct.
How about the 26th or 27th of April?
One moment, please. And that would be a lot of time. That'd be great. Hold on. Let's go with the 27th. It looks like I can do either time.
How about 11 o'clock on the 27th?
Sounds good.
Okay, April 27 at 11 o'clock for plea and sentencing. That'll be by Zoom. And Judge, what do you want to do with Estrada? Do you want to leave it for the afternoon or put it over the afternoon?
Yeah, you can do it in the afternoon.
Okay.
What was the date on Hawkins?
On Hawkins, April 27.
Okay.
And Mr. Wallace,
Ms. Wallace, Ms.
or Ms.
Alexus
Wallace, I'm sorry, is, I see the letter A.
I don't think Ms. Wallace is connected by audio.
She's been waiting since probably close to 10:30, so maybe she gave up on us or stepped away.
So, Mr. Lamke, maybe you could reach out to Ms. Wallace and try to get her to connect.
I will do so. The call went to voicemail. I left a voicemail. I'm waiting to see if I get an immediate response by text or phone.
Okay.
Patrick, I have a question about restitution in this case. Is there a claim filed? Because I'm looking through and I'm not finding it, although I feel like we've kind of talked about this.
There is, it's just under $7,000.
Did you file anything with on CCAP, or do I have it somewhere? Because I'm not finding it.
I believe that it was, but let me check.
Okay, thank you.
I believe it was sent to CCAP August 7th, 2020 at 9:48 a.m.
What are you looking for? A restitution?
Yeah,
Okay. That must have been pulled into the case because I don't see anything in the queue. Well, there's nothing that old.
check September 20,
September 20 something?
September 22. It looks like I did it. I personally, excuse me, that I personally did it. We have multiple co-defendants. Perhaps it went to one file and not the others.
I'm not seeing it attached to Ms. Wallace case.
Right, I agree.
Pat, can you give me some other case numbers for co-defendants that I can look?
I'm doing it right now. I'm just sending it again right now on all of them.
Oh, okay. Because otherwise I could copy it over.
You should have it momentarily. I just hit send, so it should be going right now again. My guess, it was in the Moffett and Whitmore case.
Yes, sometimes if I'm in a hurry, I don't catch that, but when did you say August? We weren't here yet, so it wasn't me.
Yeah, it looks like it was sent in August and then it was sent again in September. So I think I sent it twice on two different case, once on one case, then once again on a different case is what my guess is that I did.
If I see more than one case, I try to copy it over to the other one, but I don't always catch that. Doing 14 things at the same time, so.
Yeah, I understand that.
Nothing has come through just yet.
Hello?
Good morning, Ms. Wallace. Your lawyer and Mr. Lamke are just chatting with each other now. You have a light there. I can barely see. I can see well, I can't see you at all.
Okay, I'm finna try to.
Oh, there we go. All right.
Gene, what I have done is I have emailed it to you and to Mr. Lamke simultaneously.
Okay.
So, Mr. Lamke, did you get that material that Mr. Anderson sent?
Keep refreshing my email and I have not gotten it yet.
Oh, here it is. It just came into the queue. Hold on.
All right, I do have it by email. Judge, would you like me to call her and just kind of review what I see real quick before we call the case?
Yes, please.
Sounds good.
So, Ms. Wallace, Mr. Lamke is going to give you a call to chat about some restitution information. And so take a second and chat with him before we move forward. Okay?
Okay.
I'm going to put you on mute so that I don't hear what y'all are talking about.
And Judge, there was a pretrial incarceration credit also filed, which I just pulled in.
Okay.
Miss Wallace, it keeps going to voicemail. You got to answer the phone call from me. All right, Judge, we are ready.
Okay, let's go ahead and call Ms. Wallace case.
State of Wisconsin versus Alexus Wallace, 19 CF 04203, appearances.
Good afternoon, all. State by ADA Patrick Anderson. Good morning, all. State by ADA Patrick Anderson.
Alexus Wallace appears with counsel Matt Link.
Okay, so we're set today for a sentencing hearing on January 14 of this year. You know, Ms. Wallace, I really can't see you at all. Do you think you could maybe turn some lights on or do something there? Okay, there you go. So we're set today for sentencing. On January 14 of this year, Ms. Wallace entered a guilty plea to count 2, fleeing. Count 1, retail theft between $500 and $5,000 as a party to a crime, was dismissed and read in. What were the negotiations, Mr. Anderson?
Judge, in exchange for the plea to the fleeing, the state dismissed and read in the felony retail theft. The state is going to suggest a sentence of 12 months in the House of Correction. We're going to ask that you stay it for 1 year of probation, and the state will be seeking 90 days of condition time. There's
Is that
also a
your-
claim for restitution in the amount of $6,971.
Is that your understanding of the negotiations, Mr. Lamke?
Yes.
And how about you, Ms. Wallace? Is that your understanding of the negotiations?
She's on mute. Judge, you put her on mute.
Yes.
Okay. So the state did file today and may have filed earlier in connection with co-actors a victim impact and restitution document. The City of Greenfield Police Department is seeking $6,971.69 for damage to and loss of a squad car, I gather. That information was provided to Mr. Lamke this morning, and I think, Mr. Lamke, you were able to discuss it at least somewhat with Ms. Wallace this morning. Is that right?
That is, I called her on the phone. It's a very detailed statement breaking down all the parts and the labor and all the details on the parts. She has decided to go ahead and stipulate to that restitution. We don't have a basis.
So I'll set restitution in favor of the Greenfield Police Department in the amount of $6,971.69. Were there any other documents filed by the state or the defense?
No, sir, not by the state.
I know that this morning I filed the pretrial credit sheet for 10 days.
Other than that?
Not that I recall, no.
Okay. Mr. Anderson, is the state otherwise in compliance with its victims' rights obligations?
I believe so.
All right, I'll find the state's in compliance. Go ahead with sentencing, Mr. Anderson.
Judge, on the very positive side of things, there is a stipulation with regard to the restitution. The state views that very positively, and I'd ask that you take that into account. Also, on the positive side of things, there's a plea and an acceptance of responsibility here. I think that's a very good thing. What I am asking that you do, Your Honor, is place Ms. Walker on probation for a period of a year. I'm asking that you impose and stay 12 months in the House of Correction with Huber. I do believe that some condition time is appropriate. I think 90 days would be a reasonable period of time. The complaint is short, but does a reasonably good job, I think, of summarizing what actually occurred here when one looks at the police reports. We have a situation that back in September of 2019, Ms. Walker and others, one of whom I believe is Gavin Luckett, who perhaps has 7 or 8 open cases for similar type behavior, many in front of this court as well as others. So she's with Mr. Luckett and others. They go to the Kohl's department store. It's almost a brute force type of retail theft. Put as much as they can into a series of bags, grab some, and run out to a waiting car, and off they go. Law enforcement is on the way when this is going on, and one of the officers then sees the vehicle that she is driving. It is parked at a stoplight. He attempts to make a traffic stop. She goes through the stoplight. And this is occurring roughly at 84th and Layton. And I won't comment further on how busy 84th and Layton is down there. But there's a brief chase that takes us off down to Forest Home. The officer decides to perform a pit maneuver. He successfully does that. The vehicle is stopped at that point, but the vehicle then decides to accelerate backwards into the intersection through a red light and into oncoming traffic. That there is no real problem there, at least in that none of the other traffic hits her. The officer, recognizing the danger, I think rams the vehicle. Ram might be a strong word, but makes contact with the vehicle to stop this from going on. And ultimately, everybody is taken into custody. The amount of property that was taken was $3,779. So we have a fair amount of property that walked out of Kohl's of all places. It would take a fair amount to get to the $3,700. I was not able to find any real record. I did not find a juvenile record when I looked, and I did not find an adult record. The only caveat to that is I found what appears to be a burglary charge in Waukesha, but in all candor, I can't tell you for sure if that was issued, not issued, if it was issued and amended to something and expunged. I just don't know, but the documents that I looked at were consistent with a burglary being issued in Waukesha County. What happened after that, I don't know. What happened, if anything, after that, I do not know. But again, no other record, a few referrals for relative various things, but no record whatsoever. I think that there needs to be some sort of a punitive aspect given the fleeing, given the amount of damage that was done, given the danger that was caused. And the state would ask that you impose the 90 days. I don't have any additional comments unless the court has a question.
Mr. Lamke.
Thank you, Your Honor. We agree with the probation. The 1-year probation sounds reasonable. I think the 12 months HOC imposed and stayed also sounds reasonable. We're obviously asking the court for no upfront time. I think we already talked about that last time when we were in person. She does have 10 days of pretrial credit. I did submit that form while we were waiting earlier this morning. So I think that also goes towards not giving her any more upfront time for now. I also think she's expunction eligible, both her age at the time of the offense, which I believe she would have been 23 then, she's 24 now. She's just about to turn 25. I think the offense is also expunction eligible. I am asking the court to consider expunction. If you do give her some upfront time and have a report out to Franklin, we'll ask the court for Huber for child care. On the imposed and stayed time, I'd ask that to possibly involve both child care and employment. She does work, but right now she is not working. She's 24, she's single. She has a 7-month-old son, which I think she told you about in person last time when we entered the plea. She also tells me that in the intervening time since we were all together, she was in an automobile accident. She was not driving. She was a backseat passenger where a different car ran a red light and struck their vehicle. She's got 2 plates in her right arm. She's got a broken pelvis. Something happened to her ankle. She needs crutches to walk right now. She goes to therapy 2 times a week. So that's another added difficulty she's dealing with right now. She's got a cousin who's staying with her and her son just to kind of help out with everything right now because of her injuries. Her work history most recently and primarily has been as a caregiver at Dedicated Hearts Home, where it's a caregiver for disabled people. Again, right now she's not working. She's on leave. She has a 7-month-old son. She does indicate she hopes to go back to that job when it's appropriate. She also has work history at Burlington Coat Factory. She went into the 11th grade at Washington High School, but I do not believe she's graduated and received a degree yet. And then I would point out, I understand how it ended, and I agree it was probably not that major of a crashing into by the squad to conduct the pit maneuver, but it did happen. But I guess my point is it was a relatively short chase, distance and time, and I'll just leave it at that.
Okay. Ms. Wallace, is there anything you'd like to tell me? You're on mute right now too, by the way. There you go.
No.
So why did all this seem like a good idea, Ms. Wallace?
It didn't.
You know, presumably you and these other folks are together and somebody comes up with the idea of, hey, let's go take a bunch of stuff from Kohl's. And I'm just trying to figure out how you got involved in all this because you got no prior record. What's going on?
Nothing.
Okay. So, Ms. Wallace, anytime I give anybody a sentence, I have to consider 3 different things. The first thing I have to consider is the nature of the offense. The second thing I have to consider is your character. The third thing I have to consider are the needs of the public. So, the nature of this offense is you and some other folks doing a snatch and grab from Kohl's. Folks run in, take a bunch of stuff, jump in the car, you're driving the car. The police follow you and try to pull you over. You run a red light at 84th and Layton, an extremely busy intersection. It doesn't matter what time of day you're there, it's always busy. There's a Cops right there. There's Best Buy right there. It's not far from Southridge. It's a very busy intersection, and you ran through the intersection. There's a brief pursuit at that point, and the police use their car to spin out. Your response to that is to reverse through an intersection with a red light and ultimately that cause an accident. I mean, the police have to hit you to protect other people. You don't have any real insight into why you did that or what your motivation was, and that's kind of disappointing. But it's an aggravated offense because of the location. It's an aggravated offense because you were driving escape a felony. It's an aggravated offense because you nearly caused an accident that could have hurt people, and because the police had to run into you. Your character has some good things going for it. Right now, you are 24 years, 11 months, and 20 days old. Then you were 23 years, 6 months, and 4 days old. You don't have the kind of education you need. I don't know why you didn't finish your high school diploma. You haven't given me any real insight on anything else, so I am candidly not expecting you to have any real insight into why you didn't finish. You've got an employment history, though. That's good. You work with disabled people, and you work at Burlington Coat Factory. I don't know much about your family circumstance, except that you've got a 7-month-old child. That's great. I'm happy for you. I'm not hearing anything about any ADA issues or mental health issues. You have some physical health issues because you were in a car accident and received some, sounds like, fairly serious injuries. There is no small amount of irony there in that you could have caused an accident in which someone else could have experienced the same injuries that you received. You don't have any prior record. That's good. You did enter a guilty plea in this case. You stipulated to restitution. Your performance on Justice Point initially was not all that good, but got better as the case went on. The needs of the public here are just to get people to pull over when the police are behind them. You put yourself at risk. You put other people at risk. I do that. So whatever sentence I come up with has to address it. I think generally the parties have negotiated a correct recommendation here. I'm going to modify it a little bit, but I think on the whole, the probation is appropriate. And so I am going to put Ms. Wallace on probation. First, I'm going to impose and stay a sentence of 12 months in the House of Correction. That'll be straight time. I hope Ms. Wallace doesn't have to serve it. I don't think she will. I'm going to place her on 12 months of probation with the conditions of probation to include no contact with any co-actors, no contact with that Kohl's department store that was involved either. Restitution in the amount that I previously set, $6,971.69.
Is that joint and several?
Yes.
And what was the term of the probation? 12 months?
12 months. As an additional probation, I'll order that Ms. Wallace maintain full-time employment. You have to pay the costs and surcharges associated with the case. You have to provide a DNA sample and pay that surcharge as well. I do think some in the House of Corrections is appropriate. I think 45 days is appropriate. That's because of the danger that you created and the risk that was posed to others. It's also, I think, makes a point to you and to others that you can't police. I'll give you Huber for childcare on that. As to expungement, there are two things that I have to find. First, that you would benefit from expungement. I can't think of a defendant that would not benefit from expungement. Second, that the public would not be harmed. That because of your prior record, that the public would not be harmed if you successfully complete probation and you are not charged with any new crimes between now and the end of that probation, if your record were expunged. So I will grant that request. You can appeal anything that's has to do with this case. In order to do that, you have to begin by filing a notice of intent to pursue post-conviction relief. It's one piece of paper. You have to file that piece of paper in 20 days. If you don't file it or you don't file it within 20 days, then it becomes awful difficult to appeal. I'll give you until March 8th, that's next Monday at 5 o'clock to report to the House of Correction in connection with that condition time. I'll give you 10 days of credit on the imposed and stayed sentence. Anything else, Mr. Lamke?
No, I think you covered it all.
Mr. Anderson?
No,
Okay. That takes care of everything. Good luck, Ms. Wallace.
Thank you.
Mr. Lamke, I'll give you a call shortly.
Exactly. Thank you. Bye-bye.
Judge, you're
take
sending out.